how that child is supposed
What you would
to be
like to do,
produced.
Mr. Brown, is argue
I would
without
like
the
to just
benefit
have
of
it
the
dismissed.
petitioning party to be present.
Well, we don't think that's necessary because
Okay,
there's
well,
nothing adequate here in the record to bring this lady in front of this tribunal.
This matter for a hearing April 24th.
If it pleases the tribunal, I will file a petition for habeas corpus and close this place down like I did before. If you make her come back
Mr.
here
Brown,
one more time.
Got him! Got him!
Are very close to finding yourself in contempt.
Excuse me, on what authority do you sit, by the way? As a former judge here, we have a rule in the 30th Judicial District that says every single magistrate, referee has to be unanimously approved by every circuit, chancery, and criminal court judge. I don't recall that your name's ever been submitted, sir.
Got him! Got him!
This tribunal on a general sessions court's authority is insufficient to establish you. Therefore, I challenge your authority to hear it. By the way, what is that, magistrate, sir? With due respect?
Got him! Got him!
Mr. Brown, the court finds you in contempt.
Here, $10. That's all you got on
We'll
me.
sentence you to 24
You're
hours
out
in the
of
Shelby
it.
County
The
Jail.
maximum content.
You may have a seat.
I'm not. $10. That's all you got. 20. Take
Get the
two.
bailiffs.
Go find the law. Or I'm reporting you to the Court of Judiciary. I'll have you charged with violation of process. Now, you want to get into this, let's get into it. This sorry operation needs to stop.
Got him! Got him!
24 hours, Shelby County Jail for contempt.
You
may have a seat.
Excuse me.
You wish
If
to
you
have
try to
another
do this,
24
you
hours?
need to straighten yourself up and you need to
wish to
cite
have
your
a second
authority.
day, Mr. Brown.
What's that?
You wish to have a second day.
A second day.
Day.
Day?
Yes, sir.
I tell you what, you cite the authority. You find it. I looked it up before I came in here. You have $10 maximum contempt jurisdiction.
That's 2
now
days
you jump
in
in
the Shelby
here.
County Jail. You
Okay. What? I'll be out of here very shortly on a petition to habeas corpus, and I'll bring up all these problems. And guess what? You might not be operating tomorrow.
Have a seat, sir.
Okay, as a courtesy to the officers, I'll do that. Mm-hmm.
All right.
It's a circus, sir.
That's 3 days.
You can do all you want. You
4
don't
days.
have the jurisdiction I had to do it. You gotta be up above trial judge, you got $10.
5 days.
I offer you $10 to you. All right.
Judge, was this action politically motivated?
What? This is politically motivated. I went down there to see how things were working at juvenile court, and I saw a woman get done horribly wrong. She came out and asked me for help, so I said, okay, I'll take your case pro bono. I went and read through her jacket, and everything the feds has said is wrong about the way they run stuff down there was true. Rubber stamped order, no return on service, and so-called affidavit. Get this, she's supposed to be the mother of some unknown child that somebody in Virginia claims she's the mother of. She's been going through this for 8 years. There was no date of birth, no name, no birth certificate. She doesn't know who the devil they're talking about. And they had appointed some person down there to represent the out-of-state interest. So this woman's getting paid, and she had a regular day. So the woman's supposed to miss another day off from work to come down there for somebody's convenience. So I moved to dismiss this. And I said, well, first off, the affidavit is deficient as per the federal court findings. I said, you don't have a summons appropriately issued. It's rubber stamped, which is against what the Fed said and the state. And then you have no return on service. This woman's not even supposed to be here. We moved to dismiss. That's overruled. You're getting out of line. I said, I'll get way out of line. And then he went down, okay, that's one day. I said, you only have $10 contempt jurisdiction over me. I'm a lawyer. I'm not a defendant on your docket. Well, that'll be 2 days. I said, keep going. I'm reporting you to the Court of Judiciary. And by then, I learned that Brett Wyrick, who is my opponent's nephew, is down there egging him on to take me into custody and jack me up. So I think it is a disgrace and a shame, and reflective on what kind of law enforcement and prosecutorial exercise of misexercise of authority when somebody's nephew is going to try to ruin the campaign of his aunt's opponent by coming up with something like that. He didn't even have the authority to lock me up. And then we found what the delay was, is they tried to put it in like I was delinquent on child support instead of getting into it hot and heatedly down there about this. I mean, I'm a little hot under the collar. 40 years, I've never seen such a circus as they've got down there.
So now what occurs if we don't follow through with what Raleigh says? And we're battling as individuals instead of a nation. What have I been saying from day one for the last 20 years for Moors to do? Class action suits. Knowing that they're not going to do it if they lack knowledge, which is why we put information out. Because without knowledge, they're not going to do anything. But with knowledge, they begin to recognize there is remedy. But then if they don't have the courage to use it, we're fighting as individuals. And they'll use Negro money to fight you forever. So if you don't go help redeem your people, what are they successfully doing? Using you against each other?